Hey everyone, Harry here to talk about the aftermath of the Colorado Supreme Court holding and what's going on now in other states. Remember, there are 15 or 20 states where challenges like this have been lodged. The few that had gone to decision had all gone for Trump, well, really against the challengers because they were all on some kind of merits basis, like it's too soon to do this or we don't have the power to do it. It's only in Colorado that first they allowed an evidentiary hearing. That was really big, as I suggested at the time. You had a whole record and witnesses and evidence on each side and experts from which the trial judge could conclude that Trump had engaged in an insurrection within the meaning of the clause, and thereafter, when it went up to higher courts, they were just reviewing those findings the way they do any other finding in a criminal case or a civil case, with some deference and with some basis. So other courts have not had those evidentiary hearings and have kicked out the claims usually on some legal basis. And the same thing has just happened in Michigan, which is pretty significant because it's a battleground state. Colorado is quite blue, I would say, in 2024, and Michigan is one of the six or so bitterly fought over. These, the ones that in fact Trump tried to change the results and focused on after 2020. So it's a true battleground state, and a ruling that he's not on the ballot there would really have national consequences and be a real setback for Trump. All right, the Michigan Supreme Court did something a little strange. They issued a paragraph ruling that just said we're not persuaded that this is a cert-worthy question. We're not even going to take it up, basically. But there was a dissent. And the dissent didn't disagree with the bottom line. The dissent said, he shouldn't be on, but gave reasons and said for something like this, the court also should be giving reasons, should be explaining. And the dissent, if you read between the lines and even the lines themselves, it seems pretty clear that what Michigan concluded is a political party at the nominating stage can put anybody on the ballot that it wants. So it's not subject to the constitutional limitations under the 14th Amendment, Section 3. And relatedly, it's not a quote unquote state actor, the way, a government action like a Secretary of State putting somebody on the ballot, or a cop arresting you or me or whatever, that's acting as the state. They're saying it's just the political party. And they're, again, going by the dissent, it looks as if the majority of the court said, we're different from Colorado. And why is that? Colorado talks about the placing on the ballot of quote unquote qualified candidates. And that means that the candidates to get on the primary ballot are making representations that they are qualified. And that means, they're over 35, they're foreign, and they don't get axed by Section 3 of the 14th Amendment, meaning it's not the case that they, having had an oath to uphold the Constitution, thereafter engaged in insurrection. So Michigan says we're not like Colorado, a political party, which is just it's not a state actor, can make Mickey Mouse if it wants the Republican candidate. Now, things could be different when things go to the general election. The law might be different. And of course, a few different courts have basically made that distinction in holding something isn't ripe. And that is really kind of ups the ante for the U.S. Supreme Court, because in the Colorado case, they just have Colorado to review. But if they review it in such a way that keeps the door open for these other states, then the kind of chaos that I'm sure they're wanting to avoid, where a major candidate for one party is not on the ballot in some states but is on the other could still happen. And that puts some pressure on them to make a ruling that would apply to the other states, even though the other states aren't in front of them. So that's I'm anticipating the drama that will come up then, and how they're going to try to navigate that really, really tricky issue. But for now, Michigan just joins a couple other states and basically saying at the primary stage, really, there is nothing that we can do. Indeed, it's not even, they say, worthy of our review, which the dissenting judge said, come on, guys, it's pretty important. You could at least give your reasons for the people to use. Okay, so, I mean, in general, we've got our eye on the 15 or so states where something like this is still live. And the next thing that's going to happen is Maine, which has a different system. It's just up to the Secretary of State, or so it would appear. That's what the Secretary of State is saying. Secretary of State has received 3 bona fide challenges. They've been, certified as procedurally complete and and in ship shape challenges. And she says she'll decide next week if he's on the ballot. Now, if she decides he's not, you can be sure there'll be litigation in short order. But just as the Colorado case focused a fair bit on, could a trial court judge, make this sort of determination? As we know, she could, if it were like, is he 35 or not? The focus in Maine then would be, does the Secretary of State have this power? And again, that would be a whole nother problem for the Supreme Court if it's looking to ensure consistency, because they would need some kind of rationale that would also overturn. I mean, they can't overturn state law, but they would give a federal constitutional basis for overturning the result and saying, it's just categorically barred. That's really shaping up to be a very interesting, and for the Supreme Court, vexing case, because they don't want to be calling the shots for the election, but they may be stuck. Okay, so anyway, these things are going to be playing out in the wake of Colorado. While we await, Colorado put a 2-week limit on their stay, forcing Trump to petition the U.S. Supreme Court by about the 4th of January. The 5th is when the Colorado will otherwise finalize its ballot. Look for him to do it a little bit sooner than that. You don't want to risk it happening by circumstance. And now we're looking at other states that do different things. Michigan says, political parties, do whatever you want. You're not the state. Maybe we'll revisit in the general. Maine says, I'll make my announcement next week. And this is, continues to play out and raise the possibility of the Republican candidate for president being on the ballot in not all the states. And the kind of, you could call it chaos, but we're living with chaos no matter what in 2024. So it's, that maybe that'll be part of the chaos we live with, but I don't think the U.S. Supreme Court would be too happy about that prospect either. The attempt to basically give a national solution to what is a state-by-state problem is really gonna be formidable for the U.S. Supreme Court. But we're getting ahead of ourselves there. Michigan, Trump is on the ballot for now, but could be revisited in the general. If the Supreme Court leaves the room, Maine will be hearing from next week. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.